We now move on to our next presentation, which is from the Institute of Directors of South Africa and the CEO, Prof. Natesan. I hope I'm correcting your surname correctly.
Good morning, Madam Chair and committee members. My name is Parmi, the CEO of the Institute of Directors. And with me on the call today is Vikeshni, the executive in charge of policy and advocacy at the Institute of Directors. Just for very brief background, the IoD is a professional body for directors, having just under 9,000 members currently. And the IoD is also the owner of the King Reports on Corporate Governance for South Africa, and are big advocates for good corporate governance in South Africa. So we're here this morning together with the King Committee of South Africa, who just presented before us. And we, as the IoDSA, fully support and are aligned to the comments and recommendations that have already been shared by Ansi Romalo and Mohammed Adam. As such, we'll not repeat these, but we'll briefly address in our presentation 2 additional areas for consideration by the Portfolio Committee relating specifically to directors. So in relation to the various amendments to the Companies Act, or the proposed amendments, we're generally supportive of changes being proposed to promote better transparency and accountability. And with regards to director skills, we're supportive of the proposed introduction of Clause 6A in Section 72 of the Act, which allows the minister to prescribe minimum qualification skills and requirements for the Social and Ethics Committee of the board. We feel that this clause is likely to elevate the authority and effectiveness of the committee, which we believe is critical in oversight of important matters such as social and environmental impact of business. And this addition, we also note, aligns to the already existing clause for the minister to be able to prescribe minimum qualifications and skills for audit committees. However, it needs to be noted that members of audit committees and social and ethics committees are usually selected from the full complement or pool of non-executive directors on the board. Therefore, we feel that the qualification, skills, and requirements for all directors needs attention and should possibly be covered by the Act. As our law currently stands, there's no minimum criteria that directors must meet in order to be considered for appointment to a board. So whilst there are some disqualification criteria, and they set out in Section 69(8) of the Companies Act, aside from these few disqualification criteria, almost anyone is eligible to be appointed as a director. And just for background, I'll just read them out. So as long as someone doesn't fall into one of the following, they're able to serve as a director. So a person is only disqualified if he or she, 1, is an unrehabilitated insolvent, 2, is prohibited in terms of public regulation to be a director of a company, 3, has been removed from an office of trust on the grounds of misconduct involving dishonesty, or 4, has been convicted in the Republic or elsewhere and imprisoned without the option of a fine or fined more than the prescribed amount for theft, fraud, forgery, perjury, etc. And we feel these few disqualification criteria, without having at least some minimum entry criteria for directors, is the bar is set far too low. We've addressed in our comment letter that testimony before the Zondo Commission demonstrated how important a role directors play in creating and maintaining well-governed and sustainable organizations, and how dire the consequences are if they don't appropriately just discharge this critical responsibility. It's quite clear to us that oftentimes the failure of boards and the individuals on them in both the private and public sectors to understand their governance role, to fulfill their legal duties adequately, the lack of ethical leadership and a lack of governance or directorship competence often lies at the heart of many of the challenges that our corporations in South Africa are facing, and hence our country is facing. Like any other profession, serving effectively as a director requires its own unique, both functional and technical competencies as well as social and personal competencies. And we believe directorship should be seen in its own right as a profession. And as such, directors should even be required to hold a professional designation in order to serve on a board, which would ensure that they at least meet a minimum required standard, not only of knowledge and experience, but also of conduct. And I think this concept aligns closely to the national framework towards professionalization of the public sector. The Companies Act could therefore be strengthened, I think, by stipulating required competency or minimum criteria in order to be appointed as a director, especially for listed companies and SOEs, with their impact being so wide and extensive in these areas, aside from the introduction of the clause around social and ethics committees and the current clause around audit committees, where the minimum requirements can be prescribed by the minister. I think related to director competency is also director accountability. So in order to hold directors to account for fulfilling their legal duties, the Companies Act provides already a very valuable remedy for director delinquency. And we fully support and commend the extension in this bill of the time frame in which such an application for delinquency can be brought. Having said that, we feel that this remedy is not often used by companies as often as it should be, possibly due to cost, effort, and time that it takes to bring such an application to court. The one director delinquency case that we did see successful in recent times was brought about by a civil society organization, not by the corporate on which the individual was serving. So unfortunately, what we see is that directors who are guilty of misconduct are sometimes simply removed from one board, but then continue to serve on other boards. And as a result, this misconduct continues to be perpetuated in the system. So consideration could also therefore be given to requiring some sort of statutory or regulatory body for directors similar to other professions like chartered accountants, lawyers, and even doctors, who all have to maintain a certain professional designation in order to continue practicing. Naturally, as with any profession, membership of a professional body does not necessarily guarantee competence or good behavior for that matter. However, what it does do is ensure that at least there's some minimum entry criteria of basic knowledge, skills, and track record that are met before an individual is accepted. It also ensures that knowledge is required to be kept up to date through continued professional development. It ensures that the professionals who belong to a body of this nature have to abide by a professional code of conduct in order to retain their good standing. And most importantly, individuals of these types of bodies can be disciplined for infringing the codes of conduct and thus have their license to practice removed, ultimately protecting, I think, the public interest. So whilst the removal of a director's license to practice by a professional body would still require fair and due process aligned to the provisions of natural justice, it could certainly offer a less costly and time-consuming mechanism than the current court process for delinquency. So with that, we feel the Companies Act could be strengthened in terms of accountability for directors by enforcing some sort of license to operate through a regulatory body, especially in order to serve on our listed companies and SOEs. And we believe this could go a long way to improving the performance of boards by holding directors accountable for their conduct and ultimately protecting the public interest. Thank you, Chair. That's all from me.
Thank you very much, Prof. Natesan. PC members, there we have the presentation from Institute of Directors of South Africa. I'll take hands for interaction with the presentation. It seems like you are fairly covered. Members, last take. Honorable Thring.
Chair, no, I think very simply, I want to support the comments and recommendations by Mrs. Natesan, on holding directors accountable. I think that if we have some of these kinds of provisions in terms of having a professional set of guidelines for directors, like you would have for doctors and other professions, we would not have, or we may have at least reduced some of the collateral damage that we've seen from the failure of certain directors, like with Steinhoff, and currently or recently Tongaat Hulits. So I think very clearly there needs to be a tightening up, and we cannot, I think it's inconceivable that we would have directors failing in one company or on one board and then are just moved to another board. And where we seek to hold directors within the public sector accountable, I think similarly we need to be looking at holding directors in the private sector accountable, particularly where huge amounts of investment, some of your public's pension, their life savings goes into these particular companies, and where we have delinquent directors, we cannot have them causing damage and, in a sense, destroying the lives of the public. So in essence, I am agreeing with the comments made in the presentation by the Institute of Directors in South Africa. Thank you, Chair.
Thank you very much. Honorable Cloniana.
No, thank you very much, Chair. We welcome the presentations, very informative as well. I don't have much to say. I just wanted to ask one question to the presenters, that with the presentation that they've done, especially as they spoke about how a director will just be moved from one area to another area, and they don't get to account, or they don't get to be arrested. What exactly do they think that we must do to make sure that this thing of just a person messing up in this department and then just getting moved to another one, what exactly do they think that we need to do to make sure that this scourge ends? Thank you very much, Chair.
Thank you very much. I think the two questions are related. Prof. Natesan.
Thank you, Chair. Yes, I certainly agree that we definitely need to see more accountability for directors, and we need to see more consequences. This issue of consequence management comes up often in IoD events and training, etc., where people just feel that there's just not enough consequences for behavior out there. So as I explained in my presentation, is there are mechanisms to hold directors accountable, and currently the delinquency provision in the Companies Act exists. But having said that, we don't feel that we see enough of these. We have a sense of misconduct out there in general, wider than the number of delinquency cases that we see coming through our court system. And our feeling or our perception is that it's because the court system is lengthy, complex, costly to be able to bring these sorts of applications. We're currently working on a guidance note on director delinquency to try and encourage corporates to be doing more of this, so holding their own directors to account and actually taking these cases through. But having said that, I think my second point around having some sort of license to operate for directors is even more critical. You know, often with a lot of these corporate failures that we've seen both in the private and public sector, you would have seen the public, there's an expectation, for example, on a body like SAICA to take disciplinary action against members and remove the chartered accountancy designation from these members if they are found to have breached the code and acted contrary to the best interests of the organizations and the public's interest. And we believe such a mechanism is necessary for directors as well, in order for bodies to have more teeth in holding directors accountable. So just from our perspective, just to add that oftentimes when there are these corporate collapses or accusations against directors, us as the Institute of Directors being a voluntary body, we often when we check the names of individuals, find that they are not our members, and therefore we can't take disciplinary action against them, with us being a voluntary body. So I think if there was some sort of enforcement of directors belonging to some sort of statutory body that oversees them, I think it would go a long way to us being able to hold people accountable and remove their licenses to operate where necessary. Thank you, Chair.
If I may just ask a follow-up question, is there precedents elsewhere in the world for licensing of directors?
Sure. So my colleague Vikeshni may want to come in on some of her knowledge in the global space. But what we understand from our interactions on the global network of director institutes is there may not be requirements in the legislation. However, there are market forces that sort of push that directors do belong to Institute of Directors or similar bodies internationally. I think, Vikeshni, if you do have any more information on that.
Thank you, Parmi. No, globally, I think there's been a lot of debate as to whether or not there should be a need to create this license to operate or make it statutory to have a professional designation. Some of that also, I think, happened in Australia due to some of the corporate failures, but nothing's actually been done from a legislative perspective. I think a lot of our International Institute of Directors, however, do have a greater presence of actual directors being members. So I think that also helps the cause of holding accountability compared to in SA. But there is definitely, I think, talk about it, and I think given our current South Africa context, there may be definitely a need to put that into legislation.
Any concluding remarks, Prof. Natesan?
No, Chair, thank you so much for the opportunity, and we make ourselves available to work with the department if necessary on some of these things. Thank you.